Okay, thank you very much. This is the first meeting of the first public meeting of the Commission to Improve Standards of Conduct. I'm going to first ask each commissioner to introduce himself or herself, beginning with you, Robert.
Aloha, my name is Robert Harris. I am the Executive Director and General Counsel to the Hawaii State Ethics Commission.
Janet.
I'm Janet Mason. I'm on the Legislative Committee for the League of Women Voters.
Barbara.
I'm Barbara Maramoto, retired legislator for the past 10 years, and previously served 34 years as a Republican in the House of Representatives.
Flo.
Hi, good afternoon. I'm Flo Nakakuni. I'm a former U.S. Attorney for the District of Hawaii.
Sandy.
Hi, everyone. Sandy Ma with Common Cause Hawaii.
And Kristen. Kristen. Are you muted? Okay. Can you hear me, Kristen? Are you muted? Well, that's Kristen Izumi Naito from the Campaign Spending Commission, Executive Director, and she'll connect in a little bit. And I'm Dan Foley. I'm a retired state court judge. Just a few housekeeping chores before we begin with public testimony. You can go on the Commission's webpage. If you just Google Hawaii Legislature, click on House, it'll bring you to their webpage, and there's a link for the Commission to Improve Standards of Conduct. There you will find House Resolution 9 that created the Commission and set forth our duties and responsibilities, as well as members. You will see our interim report that we filed with the Legislature on March 31. Within that report are the minutes of all of our meetings prior to March 31. You will also find our subsequent meeting of April 14 on that web page, as well as the notice of this meeting and future meetings. And my understanding is YouTube and minutes of all meetings will be posted. So anything you want to learn about the Commission, that's a good place to start. Also, to communicate with us directly, you can email us at one word, standardsofconduct@capital.hawaii.gov. That's standardsofconduct at capital, that's with an O, .hawaii.gov. Last thing, the meeting today, the focus is going to be on ethics and gifts. And we do have future public meetings coming up every 2 weeks on different topics. So if the topic today is not of your particular interest, future meetings I'm sure will be. And this is all summarized in our April 14th minutes in more detail, but June 15 we'll be dealing with election law modernization, June 29 campaign finance and reform, July 13 criminal prosecution and fraud, July 27 open government laws, and then we'll have other meetings after that. There'll be no decision making today, and anything the Commission is going to propose to the future Legislature in our December 1 report will be the subject of future public meetings with public input. Before I move on to any public testimony, and we'll ask anybody who's testifying to try to limit themselves to 3 minutes each. Do any Commission members want to add anything to what I've said? Anybody up there? Raise your hand. Okay. If not, we don't have anybody physically present to testify, but we may have some people via Zoom ready to testify. So I'll open it for the first witness. Do we have?
I'd like to say something. Kat Brady.
Oh, hi, Kat. How are you?
Good, Judge Foley. How are you doing today? And how's everybody on the commission? Aloha.
Welcome. Thank you for joining us.
Thank you. I have two issues that I would like to bring up. The first one is the public trust, which is mentioned several times, 7, in the document that you offered. However, there's been actually no discussion about how the public has been harmed and how democracy has been diminished because of actions by certain people. So it's disturbing to me, since I know the legislature's rating was like 28% before this. So, public trust is, the document talks about restoring public trust. However, public trust has been totally diminished. So we need to do something that's helpful. So one of the things I'm thinking of is we can pass any laws we want, but the bottom line is there are laws and they were broken. So what if we actually focused on a statement of principles of our values as a community? These are things that are important to us: access, transparency, accessibility, accountability. Those are the things that are important, and the things that make democracy work are vibrant community participation. So I hope that you will consider maybe framing a statement of principles, and I would be really happy to give you some things that I've been working on, because I think that when people are principled, they're going to think twice about violating the public trust. Thank you so much for the opportunity to speak. Aloha.
Thank you, Kat, and we look forward to hearing more from you in the future, and I'm sure we will.
Oh, yeah.
Thank you. Do we have any other witnesses?
Gary Kuzer has his hand raised.
Am I able to make a comment to her?
You can't hear me?
Oh, hey, Gary, can you hear us?
I can hear you. Can you hear me?
Yeah,
Yes.
we can. Go ahead.
Okay,
Welcome.
great.
Good to
Thank
see
you. Thank you, Judge Foley and members. It's quite a group, and I commend all of you for the work that you do in the community and have done for many years. I'll just be brief. I did send in written testimony, and I'm hopeful that when you get a moment, all of you can look at it. I agree with Kat Brady that we need a solid set of principles, but I address 3 specific areas that I'm hopeful that this commission will be able to consider and possibly endorse specifically. One of them you're quite familiar with, and that's prohibiting fundraising during session. Not holding fundraising events, but prohibiting the solicitation and acceptance of campaign funds during the legislative session. It's common knowledge that many legislators solicit funds from people who have issues before the legislature. And it's unethical, in my opinion, that they do that. Many other states have already taken this action. So that's one, that's the easy one. The second one would be that you require, and you might have to speak to the Attorney General on this, but you require the legislature to follow the Constitution. The Constitution says clearly, and I'm going to read Hawaii State Constitution, Article 3, Section 12. Every meeting of a committee in either house or a committee comprised of members or members of both houses, this is the key part, held for the purpose of making a decision on matters referred to the committee shall be open to the public. So the Constitution said that committees shall only meet to make decisions on matters in public. And the conference committee process is the most egregious example of this. If you watch that, every single one of them just about, and maybe with some exaggeration, maybe 95%, the chair will convene the meeting and he or she will announce a decision. They clearly have already made the decision and already had other meetings between the chairs making those decisions. And the Constitution said clearly those have to be open to the public. I'm not a lawyer. Judge, I'm hopeful that you can maybe huddle with this commission and other lawyers. But to me, it's fairly clear. The third item is, and I'll try to be brief, end the unilateral power of a committee chair by requiring publicly recorded votes by committee members on decisions to hear, kill, or pass a bill. Former Senator English, during his legal proceedings, was quoted as saying it's easy to kill a bill. And it's easy to kill a bill because the chairs have unilateral authority to do so. They can either not hear it, or they can motion to defer it, and there's never a vote on that. By requiring a vote, you would greatly diminish the unilateral power of the chair, greatly diminish the opportunity for them to make these kinds of choices by themselves. Again, many other states have already done this. Many other states, there's about 25 states that require every bill to be heard. And that may be a little cumbersome, but I think it needs to happen. And there are many states that say if you're going to kill a bill, there has to be a vote. So ending the unilateral power of the committee chair, or greatly reducing it, requiring the state legislature to follow the Constitution, and banning the solicitation and acceptance of campaign funds during the session. Those are the 3 points I wanted to bring up. I know they may or may not fit in today's agenda. When you announced early to chair the topics, I started thinking, well, maybe it's not appropriate, but I appreciate the time, and I'm open to questions now or in the future. Thank you.
Definitely in the future, Gary, and thank you for your oral testimony. I've also read your written testimony, and all of those topics will be covered eventually, and I'm sure we'll hear more from you in the future. Thank you, Gary.
Thank you so much.
Another witness. Is that it? Well, that's it. Thank you very much, Kat, Gary. Look forward to working with both of you. That concludes our public testimony. So moving on to item number 2 in our agenda, discussion of ethics related reform. I'm going to turn it over to our Vice Chair, Robert Harris.
Good afternoon. Thank you, Chair. I do want to emphasize that we are going to be covering a number of topics. And so if you're trying to keep the flow appropriate, I hope you'll give me some indulgence in sort of making sure that if we start getting stuck in one topic, I may try to move forward. The idea here is to propose a number of different concepts. Some of them may not be terribly controversial, but the opportunity here is to get input, thoughts, suggestions, direction from the commission members. And then the hope is if there's sort of general consensus that this is a good direction, we might actually move to bill drafting with the idea of then having something specific to look at, to consider, and to acknowledge. But the idea here is potentially to kind of give some directionality. There are other concepts that may be a bit more controversial, and again, just having the discussion now is an opportunity to kind of get a directionality of where we should be headed, or if we need to have further discussion on it. So I hope you'll take it in that spirit of we are throwing things on a wall and trying to get input and sort of see if it's going to stick, or if it's something that should fall off and we will redirect attention elsewhere. So with that sort of general directionality of where this is going to go, let me go ahead and get started. All right, so there are going to be some different topics of discussion. So generally, one of the requests at our last meeting was to consult the different counties to try to get input from the different county ethics commissions to see if there are things that we should be looking at or considering in our discussions. And I'm going to give some of those recommendations that I heard in interacting with them. We're going to be talking about regulation around lobbyists, legislators, a concept around anti-nepotism, transparency concepts, and then sort of a bit of a fuzzy concept at the end, sort of civility, aloha, interaction with state employees and the general public. So under the Constitution specifically sets up both a state ethics commission and individual county ethics commissions. It has some very direct language specifically to them. So by framing of reference, the Hawaii State Ethics Commission has between 4 to 6 attorneys, 1 investigator, and oversees approximately 60,000 employees. The county ethic commissions, there is a range in sort of what level of funding they have. However, several of the counties do not have any full-time staff, but rather are supported through a deputy corporation counsel. And I would describe it as a high, very active, engaged volunteer board or commission. But I think just looking at the wide variety of resources, funding capacity, that this does create a genuine question whether or not the various ethic agencies are adequately funded and are able to meet the constitutional mandates that they're under. So one concept might be, and again, this is similar to the Commission on Salaries, is to look if there's either a existing or a new commission that could look at the workload, look at the specific budget allocations, and make recommendations on what an appropriate funding would be. The idea would be is that these recommendations could then be given to the various city councils or for the state legislature. The idea is it help elevate the importance of adequate resource with a focus on training, giving advice to employees, and also enforcement at both the state and county level. Again, there's different directions this could go, to be clear, but this is one concept for discussion. I see a early comment, Commissioner.
Robert, I presume that your ideas about the Ethics Commission would also hold true for the other sort of legislative service agencies like Legislative Auditor, the Ombudsman, Legislative Reference Bureau, because it's certainly possible we might encounter an ethics problem with one of them. If they, and a challenge to independence.
Yeah, so a good point, and thank you. I did say ethics, but the title of this actually specifically says watchdog agencies.
Okay.
So I think the intent was to be
Okay,
a bit broader.
thank you.
The county state separation on the ethics side is a little unique, and trying to think of a thoughtful way of being able to provide advice, but ultimately the county is going to have to be the ones to make those decisions. But the other agencies you mentioned are state, and I think they'd be entirely fair game.
And I know your idea of a selection commission is a relatively new idea, the salary commission.
Correct.
But were you thinking that the salary commission would lay out the number of staff and the types of staff, or just how would that work?
It's a good question. So again, we're using analogy. So there is a commission on salaries, which was created to create again, this is for legislators, various deputy director and director positions, et cetera. And so what that commission did, I'm just giving you the analogy first, is it went ahead and looked at comparable states, looked at other agencies, and with the idea of coming back to make, here's where Hawaii is in comparison to peers, and make recommendations about what those salaries should be. Here, for the what's being proposed here, we could go the directionality of giving a little bit more of a performance oversight. I think the intent is more of trying to review like the level of complaints, the number of complaints, are they being adequately addressed? How fast are they being addressed? Again, in the ethics commission side would be one example. I don't know if I think there would be a constitutional issue if they start actually trying to get directive and how to operationalize things, but more of just making sure the resources are appropriately set.
Thank you.
Hey, Robert,
Yes.
it's Kristen. Just so I understand you correctly, is this proposal to have a third party make some type of assessment on whether or not only ethics commissions or all watchdog agencies? So my office included would be bundled.
So when you say my office included, it makes me realize I could be walking on thin ice here. I think the intent was to make recommendations on all watchdog agencies, and maybe as a step back, I think we've talked previously about trying to protect the independence of watchdog agencies.
Yeah.
That there could be a potential for abuse, that if an agency were to vigorously do its job, potentially they could be impacted on the funding side. And I think the idea is to try to create some type of independent, objective mechanism to verify what an adequate resource could or should be. Still obviously subject to legislative approval, but then there's something sort of objective there in place.
So you're probably aware that there was a proposed bill that would have put executive department agencies such as campaign spending and legislative watchdog agencies such as state ethics and the auditor's office under one office. And we were prepared to oppose that pretty vigorously because we do have colleagues in Connecticut and Wisconsin where that model was executed and was soon thereafter dismantled. So I just want to make sure we're talking about the same thing, because I would probably like to see a little bit more have this idea fleshed out. I totally appreciate the concept, but with the idea that that could be an outcome, I would really want to be very careful about something like that. I wonder if it would not help our independence, if you will, our neutrality. I think it might become more political. That's just my viewpoint. And certainly having a third party objectively review it is a whole nother thing, but I'd be very careful for on behalf of my office to put us all together, have that concept be on the table. Just to let you know where we're coming from, because that's been our position when that bill came forth, was being proposed a session or two ago.
Duly noted. Thank you, Commissioner.
I believe that you're trying to strive for a little degree of independence so that you won't be interfered with by the legislative branch or the executive branch trying to reduce your salaries or perhaps try to eliminate certain positions. There was a case in the Honolulu County whereby the Ethics Commission the budget was diminished, and I think it ended up with a ethics staff person resigning because of harassment. So I would like to see a degree of independence. I don't know how the federal government does it with their IGs, inspector generals. But I do believe you need a little protection in case you go after some sacred cows.
Maybe if you don't mind, just for the sake of filling out and to respond to one of the earlier comments, there is no intent to put all the different watchdog agencies into one bucket or to get into any operational supervision. Again, the intent here is specific to coming up with a report of what a recommended, resource allocation would be. And again, I think that the primary imperative is, again, looking at some of the county ethics commissions where they essentially have no staff. And I think there's a lot of wonderful people trying to do a lot of good work, but there's, I think, a good genuine question of whether or not they have the capacity to do what they're expected to do under the Constitution. So that's one of the primary reasons to say we've got a problem and it's probably something that needs to be looked at. The secondary is, I think, as you mentioned, to try to create some independence and protection for watchdog agencies of, this is what, a baseline funding should be. But I certainly understand, the concern about maybe getting too engrossing or too encompassing. We don't necessarily want this commission to take over everything either. Unless there are any other comments that haven't already been addressed, maybe Sandy, do you want to go ahead?
Thank you, Vice Chair. Common Cause has seen in other jurisdictions, I believe it's San Francisco or some other large jurisdiction in California and also in New York City, where watchdog agencies such as campaign spending or ethics commissions, where budgets have been proposed by the executive branch and vigorously reviewed by the executive branch. They've been delinked from the legislative oversight in terms of being cut by legislative branch. So that's another thought. Having the executive agencies, watchdog agencies budgets be reduced by the executive branch.
Thank you. Okay, I'm going to go ahead and jump on to the next topic unless anybody has any other suggestions, comments. Okay. So this one was specific, and I'm not sure we really need to get in a lot of discussion about it. There was a discussion about, for example, currently the State Ethics Commission has the ability to have online registration, and sometimes lobbyists in particular may not realize that they also have to register at the county level. So the idea was to look for ways to streamline requirements and to allow, for example, as purely as an example, someone could register online at the state side and automatically register at the county side at the same time. There are a lot of logistical hurdles to that, to be clear. For example, different reporting periods, different reporting requirements. But I think the idea might be is to look at the statutory language to try to create some degree of flexibility to allow these types of streamlining to occur, as the counties and the state, may want to try to do this. So I think this is probably just looking for more statutory flexibility around dates and deadlines. Again, with the idea of trying to make the overall registration requirements or other analogous situations easier for, in this case, lobbyists. But I would argue also looking for similar streamlining language for people filing like financial disclosure statements, et cetera. So I don't think this one's terribly controversial, and I think the devil will be in the details. But let me just quickly see if there's any comments or. Okay. So again, these two suggestions came from interactions with the county ethics, and I did take it did appear at each, except for Honolulu, I did appear at each meeting and then interacted with staff at the Honolulu Ethics Commission to solicit input and then ask them to be engaged in this commission. So we may see some written comments at some point from them as well. So specifically on gift regulation, so this topic that we're now discussing is the idea of putting some of the same gift regulations that are on legislators and state employees and placing them on lobbyists. So the idea is to try to make it uniform. Not only is it inappropriate or illegal to accept a gift that is not reported or not disclosed or above a dollar threshold, it will also be, in this case for lobbyists, illegal for them to try to give it. So there's sort of uniformity between the two. There are, looking to other states, there are other states who've done this before, and there is legal precedent basically saying that it's okay to do specific to lobbyists. So examples here are San Francisco, Alabama, Colorado, Connecticut, and Iowa, where you're essentially banning offering of prohibited gifts, but you do create exceptions. I think what we would propose here is to try to mirror the existing exceptions. So for example, right now, it would be okay for a state employee to accept a lay, for example, that's specifically exempted. We would sort of create the same exemption, so there'd be a same uniform standard to both lobbyists and state employees or legislators. We're hoping that this would mitigate some of the overall gifts being given. If lobbyists recognized, have been trained, and know that they're not allowed to give it, then we're sort of reducing the pressure on state legislators and state employees and board and commission members from having to say no or navigate that scenario or situation. Let me pause there quickly. Is there any questions, comments? Okay. I am jumping to a new topic then. So lobbyist training. So this would be similar to the requirement that is currently before the governor, which now requires for all state employees mandatory ethics training. This would be a requirement that lobbyists would have to go through a training as a condition or a period. I think it's the actual proposal. That they'd have to do it every 2 years to match with the legislative cycle period. And that they'd have the ability to do either the live online webinars that are being offered, or they could go through a self-directed online training module and would have to be able to be certified that they completed it. We are, just for logistical ease, are proposing that it be required prior to following their lobbyist registration. There's a bit of concern that we don't want to make it too difficult for someone to register as a lobbyist. Obviously, we want to encourage people to register. However, logistically, it's just easier to make that a part of that registration process. Pause there. Any thoughts? Input?
How do you ensure that they've watched a webinar? Do you have a test afterwards, or?
There is part of the program, yeah, that there are actual tests that they actually have to be able to submit the answer to in order to get to the next section. And that's currently what we're doing for our ethics training. And so if they don't respond, they will get bounced. And I think the technology around that's only gonna get better and better.
And how long would one of these webinars take?
So the online self-directed, I'm just comparing, we don't actually have this module yet for specific to lobbyists, but for state employees, it's about 30 minutes. The trainings that we do typically last about an hour or so, maybe a little bit more. And we've actually had really great participation from lobbyists. We've had, sessions of like 100 lobbyists at a time. And I think those have been found very helpful because they can ask questions, they can hear what everyone else is asking, and get quick answers. So my guess is most lobbyists probably already do the training and would not necessarily find this onerous. And the idea is to try to catch the few that aren't going through it and try to make sure they're aware of it as well. In addition, these requirements are fast evolving. It's the opportunity of having the trainings every 2 years allows them to keep up to speed of what's happening.
The new laws.
Correct. Yeah.
Thank you. It sounds like a good idea.
I just want to add, I take the trainings.
What have you thought so far?
I do find it helpful. I don't want to violate any lobbyist laws, of course. So I do take the trainings. So thank you.
No, thank you.
I like the in-person better, but so.
Yeah, Vice Chair Harris, I have too as a government employee, and I think they're very good and very engaging. Very good use of technology.
Thank you. So now this actually may pick up on some of the testimony we received as well. So this is moving on to lobbyist disclosures. And so the idea right now is lobbyists do report on the general topics that they're lobbying on. And we're proposing something much more specific, which require them to identify the legislative or administrative action that they are working on. So basically like bill, resolution number, to be a lot more specific of what they're working on. To be clear, my guess is that this is probably going to be a bit more retroactive, as in it will show what they did lobby on with each reporting section. It's difficult, I think, to ask them to do it prospectively because you never know what amendment or change is going to happen to a statute or a bill, such that suddenly now they need to lobby on it. But the idea is it will give very clear notice to the public of what a lobbyist has worked on or what they're doing. I want to make sure that that was clear. Is there anything I can do to be try to clarify that at all? Any thoughts?
Assume it will be online.
Correct.
Okay.
I think, yeah, I would comment only that I've heard a lot of comment in this area. So I think this is a strong proposal that the commission should consider.
Yeah, so currently, for example, somebody who's working in the environment area would just report, I'm lobbying on environmental issues. You know, this change would require them to actually specifically say House Bill X, Senate Bill Y, and be very specific, which I think from a public disclosure perspective is going to be a lot more useful. All right, so these are two concepts that Commissioner Ma wanted us to discuss. And so I'm going to, if you don't mind, turn this over to you, Commissioner Ma, if you want to talk about them.
Thank you, Vice Chair. We've been, Common Cause Hawaii has been getting a lot of comments from the public about lobbyist prohibitions, and this may actually also pertain to Kristen's Campaign Spending Commission issues. It's prohibiting fundraising from candidates, and it may apply to disclosures on candidate filings. And so it's, if you're a lobbyist, that you cannot fundraise for a candidate by holding fundraisers or bundling contributions. And if you fundraise, you cannot lobby. And this is just a proposal, just to put it out there for discussion purposes. It's not a proposal from Common Cause. This is a proposal for the commission to discuss. Lobbyists may still donate subject to contribution limits that are in current campaign spending laws. Another one is to prohibit lobbyists who are advising campaigns from campaigns of any sitting elected officials or running for re-election or higher office or representing any entities under the jurisdiction of the committees that elected officials are sitting on. So those are just some issues that people are noticing, that, you know, if you're a lobbyist and then you're advising, you know, the candidate's re-election campaign, or, you know, directly trying to help candidates who are, you know, seeking re-election, or, you know, sitting on powerful committees, that creates a really strong quid pro quo and real incentive to get your bills passed. And so these are just some issues that may raise ethics concerns.
Sandy, if I have a question for you along those lines, are you familiar with other jurisdictions that have statutes along these lines?
I haven't looked, Chair.
Sandy, with regards to the second concept, for example, with that, and I don't mean to pick on Common Cause, forgive me, or, you know,
Yeah.
but I'm going to use it as an example, and I hope you understand the intent that the question is coming from. So, for example, if a candidate were to call Common Cause and say, well, what clean campaign issue should I be aware of? Would that prevent you as a lobbyist from assisting and developing a campaign platform, you know, learning ideas, you know, drafting their campaign proposals? I guess I just be concerned that some lobbyists, you know, are the specialized experts in that area. You may actually want them to be involved in those campaigns.
Yeah, no, certainly that's an area for discussion for this commission. I'm just passing on issues that some people who've more than one have called Common Cause Hawaii and wanted us to forward on to this commission for discussion, and that's really what we're proposing here.
Mm-hmm.
Yeah.
Sandy, it's Flo. So regarding the first concept, have there been prior proposed bills at all?
There's been a lot of talk this session, about lobbyists fundraising for candidates and bundling for contributions. I think Kristen could also speak on this issue. And so legislators working as lobbyists, because legislators are not full-time positions, and trying to rein that in some way, shape, or form. And it's just kind of, the idea is just all wrapped up in that first bullet, and it's not, really fleshed out in any way. It's really just presenting it to the commission for discussion.
And my question would be, what kind of conduct is covered by the word fundraising? So that means planning a fundraiser,
Yeah.
attending a fundraiser, calling people on behalf of a candidate.
Yeah, and those are really good questions. Commissioner, it's not fleshed out. But yeah, I did not, it's not a fully formed proposal from.
I understand that. Thank you.
Yeah.
And I guess I can respond to Flo. I've not seen a bill before addressing that first bullet point. And if it were to be inserted within campaign spending law, fundraising does have a definition. So it would be something, that we could regulate, though. I guess I'd be leery of how lobbyist is defined. And at one point, if you are a lobbyist or you take that, or if you're able to take that hat off. So kind of what, Gary Hoosier had mentioned in his opening remarks, making it more uniform where you just prohibit it flat out, seems the solicitation seems a little bit more easier to regulate than to define it or confine it to lobbyists. But of course, we can discuss further.
So I had a question, since you said fundraising is defined for certain purposes, is lobbyist also defined somewhere?
It is.
Okay.
Go ahead.
Sandy, I'm wondering about whether there's a timing problem with respect to the second suggestion. In other words, the lobbyist could be advising the campaign of a sitting official, but the committees that the elected official sits on could change after the election. So how would that work?
Yeah, no, those are all valid points. I mean, they could change from one session to another. Yeah.
Right.
Mhm.
Okay, I'm gonna go ahead and keep moving on. I guess, Sandy, if we want to have a discussion about trying to refine these concepts, or if we get other public testimony on them, certainly we can keep drilling down on them more. But maybe just for the sake of time, I'm going to go ahead and say, let's keep moving on.
Thank you.
Robert, it's Flo.
Yes.
I just had a quick question. So if I write on behalf of a nominee for judicial position, am I a lobbyist?
No.
Thank you.
Typically, the definition of lobbyist is going to be a number of hours and or payment for that service. So like if you're employed by a company, or if you're acting as a consultant or advisor, that's what's going to trigger the lobbyist definition. So typically somebody submitting their own comments or testifying on things is not going to be defined as a lobbyist.
Thank you.
So shifting gears now, talking about legislators, the conflicts of interest law in Chapter 84, and again, I think this first statement is maybe a little bit overbroad. legislators are not subject to most of the conflict of interest portion of Hawaii Revised Statute, Chapter 84. And the proposal here is to try to focus on amending the House and Senate rules. And so I think this also is responsive to some of the testimony received, addressing conflicts of interest and the appearance that they are just automatically allowed to move forward or no conflict is found. So the intent here is to redraft the language to make recusal a default requirement. And so anyone who has and to define conflict as something as personal, familial, business, property, or financial interest. And so if you have a conflict, that recusal is the default requirement. And then also there are situations, for example, like if you are and I'm using a bit of a broad hypothetical, something that impacts taxpayers, it's a broad class. The idea is that would be allowed, but it has to be something that's a broad class, not specific to a small number of people. So you would be allowed to vote on that. Another example would be a lawyer who is a legislator voting on something that impacts lawyers, that category is broad enough that it's not going to necessarily be defined specifically as a conflict of interest. So trying to tighten up the language and make it more specific. I have additional. And then I think the additional language you put in here, which maybe is not being picked up, was actually then also to the extent that there is a question as to whether there's a conflict of interest or a waiver would be required to be addressed by a floor vote, not necessarily waived in committee. And so the idea is that you may have a situation where there's a question as to conflict of interest that would have to be publicly addressed, or a situation where maybe that vote is necessary and that there would have to be a broad discussion of it and that'd be public and visible. We pause there. Obviously, this is a big issue.
It is a big issue, and it's a common sense solution. But we've talked before about how hard we expect it to be to change the House and Senate rules. So, I mean, are we better off to try and revise the statute?
It's
I don't
certainly,
know.
yeah. I mean, again, I think this is probably more pragmatic a question than anything else. We have taken a stab of actually looking at the rules and drafting up language already, just as a thought experiment to sort of see what this would look like. And so we can definitely give that language and let people take a look at it. And maybe do some level of like, what is the willingness? You can also do it statutorily and make it a requirement in the statute. I think the challenge is right now, Chapter 84 is administered by the State Ethics Commission, and there is some jurisdictional issues there where the legislature may want to keep some jurisdiction over itself. And again, I'm just being pragmatic here. I'm not necessarily trying to make a judgment call on that.
Yeah.
And I recognize there may be some speed and other things that the legislature has to be sensitive to of how these things can be resolved. So I think if there was an intent by this commission to look at both approaches, we can certainly look at trying to have both approaches available, or to pick one too. Again, I'm not trying to put a thumb on the scale here, just this is one idea.
Also, League of Women Voters recently had a court case on government place, and and they prevailed 3-2, but one of their three will be leaving the court within the year. And there is an issue, constitutional issue, because rule making and procedure is given to the legislature by the Constitution. By doing it by rule, you avoid any constitutional issue. Have you looked at any particular rules of any other jurisdictions that do this well?
No, mostly just focused on both the House and Senate and tried to look for ways to clean it up, but we can certainly take a look at other legislative rules. Okay. Any other comments or thoughts on this?
Excuse me, does this mean that you cannot help draft a bill? Would that be a conflict if you had to do with your profession, or usher it through committee? It sounds to me that you're just talking about the vote. Final vote.
What's being proposed here is broader. You're right. It is intending to avoid a situation where, and again, I'm picking a hypothetical where someone says, well, I can't vote, but I'd really encourage you to do this, right? We want to stop that type of, and so it is broader. It says you essentially can't work on it. So it would include, again, this is, we can talk about it, but what is currently being proposed is you couldn't lobby quietly behind closed doors. You couldn't draft the bill. The idea is this is a conflict. You shouldn't be talking about it.
Very difficult to administer. And we do have a part-time legislature. The vote is an easy part. So I like it to change to the default. Cannot vote, but it's hard to police the prior activities.
Mm-hmm. I hear what you're saying. And again, I think to some extent, if you're doing a rule change, the House and Senate would still be enforcing itself, right? And so if someone declared a conflict, it'd be up to everybody to say, hey, you can't talk about this. And that's what's being proposed here. But certainly open to suggestions if you think that needs to be changed. Any other thoughts or comments on that or reactions to that idea? Okay, moving on. So this is the financial disclosures. And so this also picks up on something that Commissioner Morimoto just brought up, is that legislators are part-time employees. And so frequently they will have other paid engagements. And one of the concerns that's been raised in testimony and brought up to the commission previously is whether that legislator may represent or be employed by a lobbyist or lobbying organization, and sort of the appearance of conflict there. So this is one proposal to look at trying to make a financial disclosure required of essentially if the lobbyist or lobbying organization would have to also be disclosed. Sorry, I've explained this badly. Let me start over. So if there is a employment or any financial relationship to a lobbyist or lobbying organization, you would have to reveal the name of that lobbyist or lobbying organization. So just basically making it transparent, the name of somebody you're working for or you're employed with that is also lobbying or a lobbying organization. We pause there. We are going to have one or two more proposals around this general topic, but I think some of these proposals could work together, or we could choose one over the other. So this would essentially be a transparency push. So I think where the rubber would hit the road would be, for example, a lawyer working for a large law firm, being employed by a large law firm that may have clients that are lobbyists or lobbying organizations. And that'd be sort of the, I think, most difficult example of, having to then also disclose who those people are. And, there would be a genuine question of whether or not that lawyer actually has any interaction, but, or, would be, so yeah, I'm giving you sort of the hardest example, but you can also have a more direct example where somebody is directly consulting or employing by a lobbyist that, seems like it'd be a much easier case to say, yeah, that should be disclosed and be visible.
Robert, could you talk a little bit more about the fourth bullet point there with the $10,000 income threshold? I'm not sure I understand all that.
I think the intent is to show that there was enough of an interaction with that client. So for example, a law firm that gives 1 hour of advice to somebody, something very de minimis, would that have to be revealed if that somebody employed by the law firm is also a legislator. The intent here would be to say something, it's an arbitrary number, but below 10,000, that would not have to be disclosed. But once you've gone above 10,000, that starts to become significant enough that maybe that now does need to be disclosed. Does that make sense?
Yeah, the lobbyist in this, I'm sorry, the filer in this case is the lobbyist. Is that right? All through this.
No, this would be the legislator.
The filer is the legislator.
Every member of the legislature to disclose.
Okay.
This could be really tough for a lawyer at a large law firm because clients are changing every week.
It is. Yeah, I mean, so let me move on to one or two of the other proposals here. And we can certainly come back to this later. One proposal that came from Sandy was to prohibit legislators from working as lobbyists or for lobbying entities. So it's instead of a reporting requirement, it would essentially be a prohibition. I'm going to go ahead and jump to the next topic just to kind of give you the gamut and then go back and discuss. Another proposal would be, in part, the reason why we're having this discussion is legislators are part-time employees. Another idea would be is to define legislators as full-time employees and prohibit secondary employment, financial relationships, and then also concurrently direct the Commission on Salaries to adjust based on this fact to be full-time, and make sure that there's the appropriate salary. I should add there are pros and cons to this specific idea. You obviously might lose some very valuable, wonderful people who currently own a business or have secondary employment and wouldn't be willing to give it up. There are some benefits to it as well, in that your ability to expand the length of time of the legislative session is greater, because now you're calling it full-time employment. You could expand how long the session goes on, which then can also concurrently have some benefits about notice, disclosure, time to discuss topics, et cetera, can all sort of also benefit from it. So again, proposal number one, which is to require public disclosure. Proposal number two is to essentially ban work with a lobbyist or lobbying organization. And proposal number three would be also similar to ban, but it's sort of going in a different direction, which is just defining the legislative session as full-time employment. Typically, if you're a state employee, you're not allowed to also do a secondary employment in the same area. So you wouldn't really be allowed to do work for other people if you're a full-time employee in this area.
What do you mean by same area?
So, for example, if you are a Department of Transportation security, you wouldn't be allowed to do security work in the same concept for in the highways. You wouldn't be allowed to do that. You might be allowed to go sell at a farmer's market, for example, but the idea is it's not related to your state job, your state work that you're otherwise doing.
Thank you.
Robert, we one trick pony here, but do we have any other jurisdictions that have full-time legislators?
Yes.
Outside employment?
Yes.
How does that work? Do you have any sense?
I have not done a deep dive into it, no. And it's something we could look at more. I think intent here is also to get some directionality of commissioners, what they think is worth pursuing more, and we can certainly dive more. Choice.
Robert, I didn't see under these legislator financial prohibition anything about protocol gifts from other overseas, or which there was a bill in the legislature this session that went pretty far to require disclosure of the gifts, a written record, and a transfer of the gifts, I guess, to the state archives above a certain dollar threshold.
Yeah, that was a proposal that we endorsed in the interim report. I can certainly, I don't see any reason why we would move off of our support of that concept. you're right, it wasn't brought up here because we already had bill language. Maybe I wasn't thinking we needed to revisit it. Between these three discussion topic proposals, is there any sort of feeling that one is clearly superior to the other, or two are clearly superior to the other that should be looked at more? Let me go up again. This would be a financial disclosure requirement of relationships with lobbyists or lobbying organizations. This would essentially be a ban. And this would be similar to a ban, but it's essentially trying to make legislators more, again, making it, recognizing, and I think in many cases it is almost a full-time job already for many legislators. This would sort of try to move more directly in that direction.
I guess I would ask Robert, what do you think is the most viable?
So we came up with the disclosure requirement. So I think that's where I was headed. And I think Sandy brought up this proposal, or this proposal. So I thought to throw in the second, in addition, the full time, just to add another way of going about it. So I clearly recommend we at least keep moving forward the disclosure. And I think maybe we can continue to talk about proposal number 2 and 3, I guess. Sorry if I didn't label them very well. I think there are some concurrent benefits with full-time, which I think should be looked at. Again, the ability to make the session longer, as much as all of us want to spend more time here in this building, I say maybe a bit of humor, and I hope that it gets caught up, would have some advantages. And I think it's worth considering, particularly you start talking about disclosure to the public, the ability to, give more notice, et cetera. If you have more time, all those things become easier.
Excuse me, Vice Chair?
Absolutely. Sandy, go ahead.
Thank you. So designating the legislature, so you're not talking about the session, you're just talking about the legislators as full-time versus extending the legislative session.
I'm probably using those interchangeably, and thanks for catching that. I would imagine that one of the benefits of saying that legislators are full-time is that it's much easier to extend the session. Again, constitutionally, it's limited to a set number of days, but you can have more recesses and more breaks and sort of essentially take more time.
Because there was a bill to extend the session to a year-round session, and that died. I think it got one hearing and then it died, and that was this past session, 2022, and it was sponsored by Senator Chang.
I think it would be difficult to talk about a year-round legislative session without also treating legislators as full-time employees. So I do think they do go hand in hand. And again, I'm not trying to say it have to be year-round or anything along those lines. I'm just saying that it gives that potential. It has other benefits, and I think just trying to make sure we're aware of that.
So one of the issues that came up was the cost of increased cost all around for the state, but just raising that.
I would agree. That you also have to offer more remuneration. And that's a separate salary commission that only meets every 8 years. So I don't think we should go down this path. I think we might talk about the other ideas.
Yeah.
I'm kind of with Barbara on that one.
I agree.
Okay. All right. Thank you.
I don't really have a position. I'm just saying that was one of the, as I recall, that was one of the things that was raised regarding that constitutional amendment bill.
I certainly understand the concern about cost. I think that's a fair concern. I think the challenge that we've wrestled with is that if you have a legislator who is working full-time for a lobbying organization, for example, or has a consulting agency or a law firm that is also working, that it's, A, there's no transparency, which is what we're trying to address now. But there's nothing prohibiting someone, for example, making hundreds of thousands of dollars on one side and then using directly being a legislator. And even if there is no conflict itself, the appearance of that is gross. So the idea of trying to create some level of, you're a legislator or you're a lobbyist, one or the other, I think is the intent here. But understood. So this is a discussion topic that Cindy Ma brought up, which is requiring elected officials to report a monthly lobbyist meeting disclosure contact log. Cindy, do you want to talk about this?
Thank you, Vice Chair. That's really all it is. Like if you have a meeting with a lobbyist, like if I'm a registered lobbyist, if I made a meeting or if I dropped by a legislator's office, just to write down that I took a meeting with a senator or representative, just to let people know that there was a meeting with Common Cause Hawaii, Sandy Ma, just to have some transparency that a meeting occurred, whether it's for a minute or whether it was for 2 hours on such and such an issue.
As the person,
I just had a question. Does that, it's not a meeting with only the elected official, right? I mean, it'd be a staff member too, or are you limiting this to the elected official?
It would be great for like staff members or government agencies, like head of DPP or something, to talk about a particular issue. It would be really great. Or if I drop by to see Robert to talk about ethics, or Kristen.
And Sandy, would it be state ethics that would be required to retain these logs or capture them? Is there a requirement of, reporting?
Yeah, it would be a requirement of reporting to the ethics commission or county ethics, if it's a county like DPP.
So this would require pretty much all department, statewide, citywide, to maintain logs and turn them in monthly to Robert's office or whatever the ethics commission's office is? Is that
Yes.
sort of, okay.
Yes, and then to be made public on the county ethics website or state ethics website to say these were the meetings that occurred. This could be fleshed out more to see what is actually workable in terms of the county ethics reporting log, what it would look like and also publicizing on the websites.
Sandy, I would have concerns. I mean, so first, I guess defining what is a meeting. So, is a text message, say phone call, is a chance coincidence in the hallway, would any of these be defined as lobbyist meetings? Would be, something we'd have to like drill down on.
Mm-hmm.
And particularly, as bills are being drafted or something, there may be mini meetings. So the enforcement of it, you didn't report such and such, hallway and somebody saw you, could be quite cumbersome from a capacity issue, as well as just the track. I mean, like this could be a lot of time and effort to try to put together something along these lines. And I guess I'm wondering if the amount of effort put into it would be, would the relative benefit of it be, equal to sort of the effort that would go into making it happen?
Yeah.
Particularly if we are also asking for lobbyists to write down what bills that they're, getting the lobbyist to report it in some ways may be easier than asking every elected official or state agency to report it.
No, I understand what you're saying. Maybe we could have a really narrow definition of meeting and see how many would turn up, because I do know that these formal meetings that get set up with legislators are important, and with heads of, executive branch agencies are important. And, but that's of course something to be discussed with this commission. If that's something that is too onerous, then of course, it's too onerous and this commission cannot endorse. So that's, yeah, it's just something to be discussed.
Are there other thoughts? To the extent that we would take time to try to develop something, are there other thoughts that this is worth pursuing, that this is something people think would be, beneficial?
I agree with your concerns. It might be too onerous. It's a lot of paperwork. And a lot of people will report, a lot of people will not.
And the lobbyist disclosure seems far more important.
Okay. Thank you. Thanks for everybody's continued attention. I recognize we're covering a lot of stuff. Hopefully shifting into everybody's favorite topic, nepotism. We currently do not have any prohibitions against nepotism. The fair treatment law that exists currently, which would allow prevent somebody from, for example, hiring somebody with an intent to favor themselves or favor others, does capture some of the concerns around nepotism. But the intent here is perhaps to try to create a bright line rule that would essentially be focused on promotion and hiring decisions. There are 27 other states that have nepotism laws in some form. And then, it obviously would create a lot more direct, a much easier to enforce situation. We are, again, reasonably narrow in saying you can't employ, hire, or promote a family member or a member of a household. It also prohibits the hiring or supervision of a business owned by a relative. And then we're proposing an exemption for existing jobs already in existence at the date of the passage. So essentially that the activity be prohibited on a moving forward basis.
Robert, it's Kristen. I'm just curious, of the 27 states that have these kinds of laws, what are the consequences of a violation?
I'd have to get back to you on that. I can't say that I know.
I'm just kind of surprised that our civil service laws, state and county, don't address this.
No. And again, I think some of the pushback we've gotten in the past in discussing it, that there is, for example, like hospitals, that are state owned, where they have been so desperate for employees, people have been encouraged to go out and ask family members to come work because they're so desperate for employees. So again, I think the intent here would be to sort of recognize some of this has already happened, and we're not going to try to get those people fired or removed, but on a going forward basis, trying to say, hey, we're not going to allow that specific type of behavior.
I remember when John F. Kennedy appointed his brother to be Attorney General, Robert Kennedy, and I remember the press questioned it. He said, well, I have to learn sometime. Okay.
So Robert, what about prohibiting serving as an officer or director of a family member's business owned by a relative?
In one context, I mean, this would be for state employees or legislators. So the idea that they couldn't also be in a business with.
Yeah, I mean, maybe it doesn't fit in here. It's certainly.
I think the intent of bullet point number 2 here is specifically in the procurement perspective of hiring a business owned by a relative, and trying to create that procurement prohibition.
Okay, never mind.
What if it's a government contract, and you're just one vote? You need a majority vote. How would that be executed or applied?
I'm not as familiar with situations where there's sort of one vote, but I think the idea is if there is a decision maker, that decision maker would either have to remove themselves from the process or would be prohibited from that contract. And we do have some similar language where that contract could be voided, for example, et cetera. But we've had situations too where a supervisor, has had a family member be hired, and they will essentially no longer have that family member report to them, for example. And so there's ways to get around it. It's just trying to make sure that there's, again, this is a little bit narrow, hiring, supervising, promoting, and trying to keep it focused on that. Not to say family members can't work from the same department or the same agency, but. Okay.
Well, I certainly think there's something there, but I would like to see if there's any component, if there is a violation, because I'm all for, if you're going to have these regulations, what are the consequences?
Sure. So we do have at least 2 state bills that state laws that we've looked at with the idea of trying to start with one of those as a draft, and we can certainly circulate the language around that. So, we definitely have a good starting point on this one. This is something we were working on last year that didn't get across the finish line. So we're a little further ahead on that one than others. Okay. So we did make a recommendation in the interim report to ask that the rules be amended to post legislative allowances online. And I guess the intent here is maybe to move past that and go directly to statutory language directing that they have to be posted and be allowed to be put online. So specifically looking at the statute and saying it has to be on the website for public inspection. So I think we've already sort of endorsed this concept. Any concerns or thoughts about making it statutory? Okay.
I do. In your meetings, Robert, with the legislature, is there any problem in doing this in execution? On a website,
I have not heard any concerns about the technical ability to do it. And certainly on a statutory basis, if there are technical challenges, we can make the effective date later to sort of allow those to be overcome. I think the intent is simply to, recognizing it is a fairly large amount of money and it's going up across, all the different legislators. It's a significant sum just to create some level of transparency and confidence and that those funds are being used appropriately. I want to be careful because I don't want to speak for others who would be the ones that actually have to do the effort of putting on the website. So I want to let them have a chance to answer, but I don't currently in exploration conversations. I don't know if there's any significant hurdles to it, and we'd love to address them if there are. Okay. And so, Kristen, in particular, I might be interested in your thoughts on this. The idea is to try to create a prohibition about using either the legislative allowance or the campaign funds for the same purposes. Currently, the campaign spending law, and please jump in, Kristen, if you disagree, allows the use of campaign funds for ordinary and necessary expenses. And so that can be legislative newsletters, attending conferences, or state travel. Legislators may also use their legislative allowance funds for the same expenses. So the idea is to essentially prohibit, you can use one or the other, but not both. Sometimes we've seen situations where a legislator will use their campaign funds to pay for something out of pocket using the campaign funds, apply for using the legislative allowance, and then when they get the state payment, they'll then reimburse the campaign. And I think the back and forth in that has created issues, since the intent here is to essentially say you've got to pick one or the other, not both.
Exactly. I think, you characterize the process very perfectly. And the times that we have done a look at these transactions, I'm happy to say there hasn't been a lot of problems, but there are problems. So I am curious what the commission feels about a complete prohibition or some type of other suggestion. I do know some people don't like the one of the 8 authorized uses of campaign funds to be able to use it for ordinary and necessary expenses, because that only applies to office holders. So you have to be somebody who was elected to be able to use that 8th type of permitted use of your funds. So if you're not elected or you're not an office holder, you're not able to use your campaign funds in that capacity. So I am curious what the dialogue is, particularly from Commissioner Maramoto, who, has been a stakeholder in this as to the impact of some suggestions like this. But of course, I'm all for transparency and would support something along the lines of what's being suggested here.
I don't think I'd have any opposition to keeping a bright line there, separating campaign fund use from regular and other funds. But, I just was trying to remember if I had ever used both for an occasion or an event or something. I can't think of any offhand. I think it's better to keep that bright line.
Kristen, any other comments on this?
Yeah, I guess we've been told by legislators that they have more timely access to their campaign funds than they would have to their legislative allowance. And therefore, this has been helpful to them. It certainly on our part has been appropriate, or lawful if it's ordinary and necessary. But of course, when we find that the legislative allowance was also tapped and that the campaign was not reimbursed, of course, that is a problem. But as I mentioned, the times that we've taken a look, it wasn't like an egregious area.
Okay, thank you. So this is the last topic, and I think it's the fuzziest. And so I just say it's maybe more of an open conversation. And so maybe when we've gotten written testimony previously, so this is sort of trying to address that, and this may be something that gets picked up in some other meetings as well. So 3 types of complaints that we've heard about is where a lobbyist or a member of the public has been threatened by a legislature. And again, the threat is maybe in the eye of the beholder as well, to be clear. And so trying to verify, is this truly a threat, or is this just inappropriate language, or is this sort of normal legislative prerogative? We'll cut the funding to a program you care about or your program you like unless you do X. And we can create all sorts of hypotheticals that go the gamut of sort of appropriate, normal regulatory behavior, like you need to be more efficient in your program, you need to do better, otherwise, like we're gonna have to cut this program. Versus the, you need to hire my brother unless you, and if you don't, I'll cut you. So again, you can create hypotheticals and run the gamut. Similar kind of example where it's a state employee threatened by, so taking an fictional action or will impact positions in your budget, will impact your department. Again, ranges of this. So on sort of the high end of the range, I would say, there are definitely existing ethic codes that may come into effect. So, direct abuse, where you're saying, hire somebody or we're going to cut your budget. We may have some ethical rules that apply, but on the lower end of this, there may be sort of a situation where we're just saying, is this appropriate? You've crossed a line here in sort of how you've interacted with either a member of the public, a lobbyist, or a state employee. The third example is probably the most classic part of like a civility rule, which is just rudeness beyond the pale, direct swearing, cursing, being just hostile to somebody. And so these are sort of the problems, and I'm just trying to set up what the issues are that maybe trying to address. So some of the challenges that occur currently is like a lobbyist or state employee may not want to come forward, recognizing that, you know, if they complain about an important legislator or somebody with a high degree of power, that there may be a retaliation and concern that the current process may not have an objective review. I can give some examples of that in the past, I mean, if necessary, if anybody sort of wants to dive into it more, but hopefully this general statement is broad and good enough. And so again, as I said before, Chapter 84 may pick up some of the situations. They get more direct, more of a threat, or more an abuse type of situation, but there's definitely some range where it becomes a lot more difficult to use Chapter 84 specifically. And even in a situation where Chapter 84 applies, the remedy may ultimately be a referral back to the legislature anyways, because we don't necessarily have the authority to, the Ethics Commission doesn't necessarily have the authority to do some levels of discipline to a legislator.
You know, I mean, I think the idea is great, but how do you write it? How do you enforce it? The one thing that comes to mind, I wrote the rules for the Applied Civil Rights Commission, the sexual harassment, because a lot of it is urban. And you have to be very specific if you're going to be able to enforce it. So that's, I mean, the idea is great. I'd like to see more aloha and civility and avoid the examples you gave. But how do you do it? And who's going to enforce it? And how do you write that code? Because it's going to have to be specific.
Agreed, and those are very great comments. I think also we have to recognize that the legislature has some inherent authority to govern itself. So one idea, and it's an idea, and hopefully there are better ones, might be, for example, allow for a process that does some type of independent review, you know, and help protect confidentiality where necessary. And then if there is a finding that there was a problem, that there is a way to then report it back to, you know, the rules currently typically will have a standards commission already, you know, or a process creating one. You have now an objective report to come back and say there was an issue here. You now need to look at it, you know, pursuant to the legislative rules. And so it's just creating maybe an intermediary, maybe even analogous to the ombudsman's office to try to help investigate and help allow those complaints to come up through the process. Whereas currently there may not be that process in effect. Like I said, there may be better ideas out there.
These examples that you gave are certainly quite different in terms of severity, really. You know, I mean, to be rude is one thing, but to threaten somebody is much more serious. So.
Yeah, and so I did also present this to my ethics commission. They made the exact same point. Threats are something completely different and might even cross at some point like a criminal level or a violation. And I did keep these together because it is difficult when we've had the situations arise to parse between where does this fall. So a example might be, again, you know, you need to hire somebody really good for this position because, you know, your department's really not doing well. And that might be heard by somebody as you need to hire someone specific, or there'll be a, which, you know, is directly kind of giving a threat and giving a violation, but the legislator may mean you need to do better, right? Like my job as a legislator is to ensure proper performance. And so trying to separate and figure out, is this a threat? Or is this just enforcement regulation is tricky to do. And you sort of need a process to do that effectively and to get all the facts and try to come to a conclusion of, yeah, that crossed a boundary or that was just inappropriate language maybe, or not very carefully worded language. So hence the blurring of it is difficult.
Hey, Robert, this is before my time, but I think certain attempts in this area were made in the campaigning or election process and was struck down in the federal courts. But of course, this was maybe 20 plus years ago, so I'd have to look back into it. But I do believe our general counsel, Gary Cam, when he was working at the Attorney General's office, represented the commission in federal court, challenging these types of civility programming. And so I'll circle back on that, but because but it's the same kind of concept, which I think is really great too. I agree with Judge Foley. I think it's an idea is really great, but how do you enforce it?
As I preface this, this was one is probably the fuzziest topic and one that I'm not necessarily coming with something very specific or helpful here, but we've heard, I received one complaint from a well-known, well-respected lobbyist saying that they got a call at midnight, very harassive, like, how dare you take a position on this bill that's like this? Your entire success is based on legislature approving your programs. And, there was an issue there that there was really no clear remedy. And so I think that's one example. We have also received departments, some of which has now become public, complaining that certain, that they were having positions cut based on the fact that they hadn't done something a legislator wanted to do. So again, there's real examples of this going on, and there's no real clear answer of how to address it or solve it. And so the intent here is just to maybe start the conversation, and maybe we'll just let our brains percolate a little bit on it, see if we can come back to something better. But there's plainly a problem, and again, I'm not quite sure how to fix the solution.
Vice Chair?
Yes.
If I may, I don't know, I'm sure many people on this meeting have heard Senator Ihara often proposes for people running for office to sign this pledge of fair campaigning, to have, no mudslinging, type of like civility and campaigning. Maybe it's just having legislators before the start of each session signing a pledge of civility and conducting themselves during the session. Maybe it's just something as similar to that, like a voluntary pledge.
I hear that. I guess maybe I want to separate the I hear that, and I definitely think the electioneering and campaign examples I sort of feel are maybe a little bit different, and I do want to separate. Obviously, politics can be a rough and tumble game. However, there's also some level of power and authority, and similar to like a sexual harassment, there's just that power of authority. And maybe aloha and civility is the wrong title for it, because maybe it's sort of leading us in the wrong direction. It just allows for abuse of that power structure. And so I think it is trying to capture that, where maybe a member of the public comes in, and if they get, yelled or sworn to, it really creates a perception that they can't be involved in the political process. And so it does feel like it should be more than just voluntary. It should be in the nature of like, this is a requirement of being in this office, that you're going to treat the members of the public with some level of decorum and respect. And that should be a requirement, not simply just voluntary. And again, I don't think those examples of really being rude and abusive are common, but we did, I think we've all received some of those comments from members of the public, reporting specific examples that we know they do happen sometimes, and there may not be a good remedy right now.
In fact, don't they have similar rules already in both the House and Senate? So there is similar rule about decorum with the public. I think so.
Correct. I think
I
the,
know lawyers have that civil code, but it's
Right.
on breach.
so I mean, again, I think I did give the, the concern of, it is difficult sometimes, particularly how does someone report it and not, worry about, what would happen to their career, to their cause or to their issue.
I think I understand what you're trying to say. When somebody is in a position of power and holds the life or death over you, then when you're threatened, what do you do? And the solution is a little difficult. Like if it's sexual abuse, if the victim just feels threatened, that's enough to start an investigation. But this is a different situation, unless it's a physical threat. There's a lot of different types of threats.
So Chair Foley may have had the best examples. Maybe just we need to come up with very specific language about specific circumstances, and then once we sort of have that, consider what the appropriate process should be or could be to address it. Again, it feels like some level of independent review or objective review would be helpful, rather than having to report, for example, to the legislator that caused the problem. So, it's just trying to figure out, the specific examples of boundaries that shouldn't be crossed, specific language, and then sort of figure out the process to resolve. Maybe it's the best way to move forward. Clear, this might be a little bit outside of ethics per se. And maybe also, I think we talked about at some point, looking at the legislative process. And this bucket of issues may sort of fall more appropriately in that. However, I guess you could also argue that maybe some of the same concerns could be said about, heads of agencies or, governor's office, et cetera. So, who knows? But happy to maybe take a stab at trying to do another work on this and then come up with something a little bit more specific. If anybody has any other ideas in the interim, all ears.
Becomes under power politics.
That is the end of the presentation. So
Okay. Do we have any questions on any of it for Robert? No. I want to thank you, Robert, for the comprehensive. And from what I understand, you're going to be working on proposed legislation for many of these ideas.
correct. So I think the intent is to take stab at either drafting rule proposals or legislative language, and then being able to tee it back up to the commission to consider the specific language.
Now, will you be able to post your slideshow on our webpage?
It has been posted.
Okay.
Thank
the
you.
house, so
Thank you to the
anybody
wonderful staff.
watching YouTube, you can see this again. You haven't had enough already. Okay. That's it. Now we're going to the last item on the agenda, other matters. Janet, Barbara, Robert, anything? Other matters? Sandy, Flo, Kristen?
Maybe just a reminder that Sandy and I would really appreciate having comments on our draft agenda for the 15th by Friday.
Okay, I thought it was fine.
Okay, thank you.
And for those tuning in on YouTube, June 15, 2022, election law modernization led by Commissioner Sandy Ma and Janet Mason.
Sandy does have her hand raised.
Sandy?
One quick question for the public written testimony that were submitted for today's hearing. Will they be posted online, or have they already been posted online?
No, it hasn't. Are you requesting that it be posted, Sandy?
I'm just asking, will they, if they have not?
I think the commission can post them. So I think maybe this is a discussion for the commission of whether or not they want all the testimony to be publicly submitted. I do think that in general, that's a very good idea, but there may be some people who want to submit something that might be confidential or personal, whether or not we want to create a mechanism for that. Like, for example, we talked about some of these issues with specific legislators. They may want to try to keep some of that confidential. And is there a thought process, or do we just say everything's going to be public? Okay. All right, so the hearing notice does say everything will be posted publicly. So unless there's any objection, Chair, maybe you could just.
Okay, so will be posted, Sandy.
Okay, thank you. I was just curious. I didn't know. Thank you.
So if there's no other matters.
Kristen.
I want to thank Gary and Kat again for tuning in. This isn't really on the agenda, but since we only have the two of you, would you like to add anything before we close? Kat? You're mute.
Sorry about that. I'm going to be working on a statement of principles, which I'll be happy to share with the commission.
Okay, that'd be great. Thank you, Kat. Gary?
Yeah, thank you. I really enjoyed listening for this time, so I appreciate the effort. The last conversation that about the civility and aloha and the abuse of power is one of the points that I tried to make in my testimony. And I think one of the solutions is to reduce the unilateral power of individuals by requiring votes of the committee.
Yes.
And they would have less, they can't just snap their fingers and kill a bill then. They have to actually get votes on it. And I think that would greatly reduce that unilateral power that leads to abuse. Another thing, quickly, I don't want to take up too much time. In terms of the training, I believe most legislators don't realize they're not administrators, that state employees work for the governor in general. They don't work for a certain senator or House member. And so I think they might need to be reminded on that. On the council level, it says in our charter that we're not allowed to give instructions to county employees. We have to go through the mayor. And I'm not sure the legal side of the state employees, but I know the micromanagement is a bit much. But the main point I'd like to make is reducing the unilateral power of chairs by requiring a vote. And then you spread that accountability among the committee. The committee has to agree. So thank you. But thanks a lot. I was actually inspired by the conversation. I appreciate the thought everybody's putting into this. And I intend to keep listening.
Appreciate your input, Gary and Kat. Thank you for sticking with us. That concludes our agenda today. And
Wait, is Kristen?
Kristen has been trying to say something.
No. I just want to just a clarifying point, particularly for those who have, taken the time to, come to this hearing. Are we allowing them to write to us if they have any further comment, after they've had the time to digest what we've discussed, or a thought? Because this was a lot to discuss. What is our next step as a commission, other than, I'm sure, Robert, as state ethics, is going to pursue some of these concepts. But I'm just curious, are we circling back, or how is this, what's our next step? And how does the public interact with that?
the public, including Gary and Kat, can interact with any commission member directly, or the commission generally through its email or through future meetings. I think we're open to any suggestions. For example, Gary was talking about a particular suggestion. If you'd like to send us, Gary, what you think would be a good rule amendment to accomplish that for the House and Senate rules, we'd be open to that. So the way I see the commission, Christian, we're open to any public input from individuals at any time on any topic.
Sure. Also, we should also note that we do have the next 3 or 4 commission meetings on certain topics set. But I think we deliberately built in a pause to have an opportunity to, set the next meetings, whether we're going to revisit some of these topics, spend more time on them. So the idea is that we sort of have, every 2 weeks, we are having a meeting going up until the December timeframe. And so it is a pretty aggressive timeframe. But we do have the ability to kind of circle back. And so if somebody comes up with something that maybe has already been talked about, or we need more time on something, we do have the ability, essentially to set another meeting aside for some longer, deeper discussion about something. My thought is, as we come out of each of these topic meetings, that we will sort of have a working direction of where we want to go, and then the ability to hopefully come up with some specific language around it.
And through the process, it really necessitates circling back, because ultimately we're making recommendations to the legislature, which is enactment of a bill or promulgating a new rule or amending a rule. So we're going to have to consider those proposed bills and rules changes and discuss them. So we will be coming back to all of this. Sandy?
I'm just saying I have to sign off. Thank you, everyone.
Thank
Sorry.
you, Sandy.
Could I say hello to Kat? I want to say hello to Kat because
Hi.
for 10 years, so aloha.
Aloha.
Okay, so no more comments. We'll conclude the meeting today. Thank you, everyone, for attending. Aloha.
Aloha. Have a